Hi everyone, this is Daniel Tekanoff. In this video, I will show you how the Convention of States position violates basic separation of powers principles. Know the difference between a convention of the people and a convention of the states. A convention of the people are where elections are by the people for the special purpose of constitutional amendment. The elections are equal one person, one vote, and at the convention, the delegates would have the full power to do a clause-by-clause review. A convention of the states is basically a convention of the state legislatures, where the state legislatures would control appointments to the convention. They would force their delegates to participate in a one state, one vote process, eliminating sovereignty by the people, and they would assert the power to limit the topics and how much time was spent at the convention. We already have Supreme Court law that makes clear that the state legislatures have no power to give limiting instructions regarding the national power to amend the Constitution. Basic separation of powers forbids a convention of the states. Remember, the federal system includes both the separation of powers between three branches of government, legislative, executive, and judicial, but also the separation of powers between the national government and the state governments. James Madison described this in Federalist No. 51. The power surrendered by the people is first divided between the two distinct governments. And there must be a clear separation of powers between the two, the national government and the state governments. The Convention of States position attempts to exploit a defect in the Article 5 Convention Clause. Here is the Article 5 Convention Clause in red. As you can see, it's quite short. The Congress, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments. The text in blue is the ratification clause. What Article 5 is missing is an elections clause for the Constitutional Convention, and this is what the Convention of States seeks to exploit. But the legal analysis is already quite clear. The Supreme Court has already made explicitly clear that the elections clause in the Constitution is the only power that state legislatures have with respect to the national system in terms of elections. In the 2001 Supreme Court case, Cook v. Graylicki, the court stated that no other constitutional provision gives the states authority over congressional elections, and no such authority could be reserved under the 10th Amendment. By process of elimination, the states may regulate the incidence of elections, including balloting, only within the exclusive delegation of power under the Elections Clause. Article 1 has an Elections Clause. Article 5 does not have an Elections Clause. Therefore, the state legislatures have no power over the Article 5 elections or the procedure. A convention of the states would give the state legislatures the power to disband the Union, which was not intended by the people. If you look at the Article 5 convention process as having three stages, a beginning, a middle, and an end, we know that the beginning starts in a one state, one vote process, not democratic, in order for the state legislatures to vote for the convention to begin. At the end, it's also one state, one vote in the ratification process, also not democratic. So the convention itself has to be closer to the people. It can't also be one state, one vote, or that would actually give the state legislatures the power to disband the Union. The power of self-preservation is a basic principle of constitutional government at the national level. The national government must maintain a power to preserve itself. And remember, we go back to the McCulloch versus Maryland case. If you had state power to tax the federal government, it would be the power to destroy the national government slowly. So if you had state power to amend the federal government, that would be the power to destroy the federal government quickly, and that can't possibly be the proper result. So under the power of self-preservation, the people must maintain power over the Article 5 convention for proposing amendments itself, and that means it must be one person, one vote. The fact that the 10th Amendment reserves power over the Constitutional Convention to the people rather than the state legislatures is stated in various places, in various Supreme Court cases over time. It relates to the concept of sovereignty itself, and here we have again in the 1995 U.S. term limits case, the Supreme Court states very clearly, sovereignty is vested in the people, and that sovereignty confers on the people the right to choose freely their representatives to the national government. Let's close out this video with this positive thought. Consider the effect of the 14th Amendment and the absence of an elections clause in the Article 5 Convention Clause. The 14th Amendment includes the Equal Protection Clause, which provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. Because there is no elections clause in Article 5, that would mean that all citizens have an equal right to attend the convention as a delegate, at least at the first meeting, at least until a ratio of representation is voted on, at least until there is some vote by the entire nation as to how many delegates should be attending a constitutional convention, how robust the representation should be. We have a number of free civics education videos available on this channel. They are all freely available to you. For further study, I invite you to take a look at my book, Guide to the First Article 5 Convention of the People.